Mm. I beg to appear, my lords, in the writ appeal at 1.2. Ask him.
Video problem agaiತೆ online ಅಲ್ಲಿ ಇಲ್ಲಿ ಆರಾಗಿದೆ.
Yes.
No, I appear not in writ appeal 1006 of 23. Yes. Court administration. We were respondent number 3 before the learned single judge. We are respondent 3 before the learned single judge. The prayer in the writ petition, my lord, your lordships may please take note. Page 180. There are not 3 volumes which contains all the papers. There are other 2 connected appeals, my lord, in which the other contesting respondents who are affected by this order are before your lordships. The prayer in the
I
writ
happen to
petition,
appear, my lords, in one of those appeals.
page 100 and
That
Yes,
is
yes,
1.2.
yes,
I think
yes,
Mr. Aditya Sundi also appears,
Grateful.
my lord.
yes,
Page
Yes, my lords.
180.
I'll submit after my esteemed friend. Lord.
yes, yes.
The first prayer is, my lord, is call for records relating to seniority list. Then, my lord, issue an order quashing the final seniority list annexure A. My lord, this may not survive at all because annexure A, my lord, during the pendency of the proceeding, there was objections that were filed, and after that, my lord, a final seniority list was issued as per annexure N, which your lordships will get at page 548. Therefore, my lord, they filed an amendment application and they challenged that. And that prayer, my lord, is annexure, prayer number E at page 180. Quash the impugned seniority list, final seniority list dated 16/3/22, published by third respondent insofar as rankings assigned to petitioners and respondents are concerned. And consequentially, my lord, please notice this, to redo the seniority list by placing the petitioners over and above respondents 13 to 82 in the interest of justice. My lord, in the array of parties, respondents, my lord, 13 to 82, they were, my lord, persons who were placed above these writ petitioners. My lord, there are 4 writ petitioners. All of them, my lord, are direct recruit judges who were appointed with effect, my lord, from 1/2/2016. Their grievance is that the promotions that were made before they were appointed, the proportion was not maintained between, there are 3 streams for appointment, my lord, of district judges. Stream number 1 is by promotion from eligible judges who are not senior civil judges. Stream, that's 65%. That percentage has varied, but we are agreed now what should be the percentage. It is 65% should be by promotion. 10%, my lord, in addition, is by competitive exam taken by the senior civil judges. The remaining 25% are direct recruits. My lord, in this interregnum, one other aspect will come up, my lord, which your lordships will see as we go along, is what should be the status of the fast court judges, fast track court judges. The law on the point, my lord, is very well settled now. It has been laid down by this Honorable Court and by the Honorable Supreme Court, that if under that special scheme of formulation of fast track courts, if some judges were appointed to fast track courts and they will get their seniority as district judge only when the learned judge would have normally got his promotion in the normal course. Because these extra courts were created, some were placed there. So they will not get seniority from the date they actually started functioning as fast track courts, but it will relate only to the normal day when the learned judge would have got promoted. That seems to be the legal position. There's some confusion on that, my lord. I will try to clear it as I go along. Now, my lord, the main contention, if your lordship have the writ petition now, the grounds, my lord, which they have raised are at page 168. The first ground relates, my lord, to Annexure A, which as I submitted, my lord, may not survive. And the second ground at page 169 is the one which will fall for consideration. But the thrust of their case, my lord, is at page 171, ground number 5.5. This is the main point which all of us, my lord, labored before the learned single judge and before the division bench, my lord, in appeal. If I may just be permitted to read the first portion of that ground, my lord. The quota rule prescribed under the 1983 rules as well as the 2004 rules are required to be strictly adhered, implemented and followed. While preparing the seniority list, since the rules of recruitment provide for different sources of recruitment to the cadre of district judges, the said quota since 1983 is not worked out before finalizing the seniority list. If I can just pause, my lord. In the writ petition filed in the year 2020, those who are appointed in the year 2016 are raising a plea that this quota rule has not been followed from 1983. So whether they can raise it, if so, which should it be examined, is one aspect that will fall for consideration. But my submission is, my lord, that the quota rule has been followed to the letter and spirit. There is no violation. Then, Lord, if I may continue reading. The impugned seniority final list is contrary to the principle laid down with the Honorable Supreme Court in the case of V.B. Badami and Gonal Bhimappa. Block periods are not made from one direct recruitment to another direct recruitment or to the date of amendment of the rules. The posts are not classified among the three sources of recruitment as provided under the rules. The Honorable Supreme Court in Badami case has held that quotas which are fixed are unalterable according to exigencies of situation. One group cannot claim the quota fixed for the other group, either on the ground that the quotas are not filled up or on the ground that because there has been a number of excess of quota, the same should be absorbed, depriving the other group of quota. Even in Gonal Bhimappa, Honorable Supreme Court has reiterated that fixation of inter-se seniority in the gradation list has to be worked out on the basis of the quota. Thus, in the absence of classifying the vacancies based on block periods, the impugned final seniority list not in accordance with law, same is liable to be set aside. This is the main contention. And next, kindly skip one page, not please go to page 173, ground number 5.7. The vacancies available under the promotional quota of 65% is to be worked out from the date of commencement of 83 rules. Excess promotions granted after 83 would have a cascading effect upon respondents 4 to 82, and they would consequently be pushed down in seniority list for want of vacancies within their quota. Though there is no vacancy available within the 65% promotional quota, respondents 4 to 82 are promoted to the post of district judges. Hence, respondents 4 to 82 who are promoted in excess of the 65% quota cannot claim seniority over the petitioners and are liable to be pushed down and placed below the petitioners. Now, for this promotion of respondents 13, my lord, to 47 and the rest of them, it has taken place, my lord, in the year 2015. So it is nearly a year prior to the writ petitioners being selected and posted. So what they're saying is now, well, I got appointed in 16, but there are some people who are appointed before me, and their promotion was not in accordance with quota rule. Therefore, to give me relief, you repair them and relegate them to the position which they would have got correctly if the correct quota rule was followed. That's their sort of involved logic. And my answer to that is, first, they can't raise it. Second, it has been done according to the quota rule only. There is no violation. And the prayer your lordship saw is to redo the seniority and place the petitioners over respondents 13 to 82. In other words, if that happens, then the learned judge has directed that they will all be demoted and sent back to their original positions on this reworking of this. That one of the submissions is that such prayer is not there and cannot be granted. But I'll take your lordship now straight away, my lord, to the stand which the High Court has taken in the statement of objections, my lord. Kindly, my lord, take my statement of objections. Statement of objections. Page number 588, my lord. Should be, my lord, in volume 3. I'll only show, my lord, two documents, the statement of objections, and there is a sur rejoinder. Volume 3, page number 588.
Volume 3.
At 596, my lord, I'll skip the preamble, my lord, where is repetition is there of what they played and all that. I'll come straight to the point. Page 596, paragraph 10. The respondent, in compliance with the said directions of this honorable court, prepared a fresh seniority list reckoning the seniority of the promotees from the date of their appointment to the substantive vacancies. Accordingly, a provisional seniority list was published in the official website of the High Court on 26/7/2014, which is Annexure C. On 26/7/14, the cadre strength of district judges was 258. Hence, as per ratio fixed under the 2011 rules, the cadre strength of district judges was qualified as under: district judges by way of promotion 168, district judges promotion cadre on the basis of merit department exam 26, by way of direct recruitment 64. After considering objections raised against the provisional seniority list, the Honorable Special Committee in its meeting of 22/7/15 resolved that the objections raised are without merit. However, the Honorable Full Court in its meeting of 8/9/15 resolved to refer the matter to the committee for reconsideration. On reconsideration, the Honorable Special Committee in its meeting of 21/16 resolved to prepare a draft seniority list from serial number 38-283. The said draft list was circulated among all honorable judges soliciting views and suggestions. Honorable Full Court in its meeting on 5/7/16 resolved to approve the provisional seniority list dated 7/6/16 and directed the registry to publish the final seniority list. Accordingly, a final seniority list was published on 18/7/16, which included petitioners at serial number 381, 382, 385, 388, as they were appointed as district judges on 21/1/16. This 21/1/16 is the date of appointment. It is effective from 1/2/16. Not that it makes a difference, but just for record. The officers at serial number 1 to 37 in the provisional list dated 26/7/14 were regular district judges. Hence, there was no dispute regarding their seniority. Hence, their names were not shown in the final seniority list. The dispute in seniority arose only after establishment of fast-track courts in the year 2003, and hence, their names were also not shown in the final seniority list. Now I come a lot to 2016. What happens at the time these people were appointed? As on 18/7/16, the cadre strength of district judges was 340. Hence, the ratio fixed under 2011 rules, cadre strength of district judges was quantified as under. District judges by way of promotion 221, that is that percentage, not 65. District judges promoted 34, direct recruits 85. As per final seniority list, officers were classified as against the substantive vacancies as under. Officers at serial number 38 to 105 were fast track court judges who were promoted against clear vacancies. Therefore, they were assigned ranking as per their substantive appointment as observed in para 84 of the judgment. That's what I was pointing out. Fast track court judge appointed, if there was a substantive vacancy, then he or she would become eligible from that day. If there was no substantive vacancy, he or she would discharge those duties till they get the normal time when they get appointed. Officers at serial number 106 to 112 were directly recruited to the post of district judges and assumed charge on 25 to 2008. Then, my lord, I give all the details, my lord. I'll skip over the details, my lord. Not necessary. Then, my lord, now kindly go to page 601, para 17. Thereafter, in consideration of representations to rectify the mistakes and errors in the special committee, it resolved to redo the seniority list. Thereafter, a fresh provisional list was prepared and published to the official website on 39/21, Annexure K. In the said list, respondent taking into consideration objections raised by petitioners. The petitioners are placed above respondents 4 to 12 who were appointed after petitioners are appointed as district judges. After considering other objections received from petitioners as well as others, Honorable Special Committee rejected the same and recommended publication of final seniority list in terms of the provisional list dated 39/21. In accordance with the said report, the respondent published the impugned final seniority list on 16/3/22 Annexure N. That is what, my lord, is now challenged by means of the amendment to the writ petition. Then, my lord, for illustration, I pointed out at para 19, page 602, what happens in 2022, that is the time of this new final seniority list. As on 16/3/22, the cadre strength of district judges was 374. Hence, the ratio fixed under 2011 rules cadre strength of quantified as under. District judges by way of promotion 243, promotion by examination 37, 94. The seniority list published in accordance with ratio of the judgment in Registrar General versus so and so. Further, all promotions under 65% court category were made against vacant posts and no excess officers were promoted. No excess officers were working under the 65% category as on the date of appointment of directly recruited district judges during 2016. Therefore, viewed from any angle, the above petition is not sustainable. Now, my lord, this is further amplified in the Sir rejoinder which I have filed, which your lordships will find at page number 737 in the same volume. My lord, after this, at the hearing, the Honorable Court also wanted to peruse the records of the Honorable Court. So we placed, my lord, on record the proceedings of the committees, the various notifications, my lord, that were issued by government increasing the cadre strength, except in one case, one post was abolished. All other cases were increases. This is the Sir rejoinder, my lord. At page 738, I go to the position, my lord, when these contesting respondents were promoted. What was the position on that day? Para 3, page 738. On 1/3/2015, the sanctioned cadre strength of district judges was 259 as stated above. 65% quota of the sanctioned strength for promotions in the cadre of civil judge senior division on the basis of seniority cum merit would amount to 168. The working strength and vacancy position in 65% quota of district judges on 1/3/15 is as below. So I have given them. Total strength was 259. Sanction which they could have occupied is 168. But those who are actually occupying in that stream was 123. So there were 45 vacancies in that 65% quota stream. Then, para 4. It is submitted that 39 judges, including respondents 13 to 47, were promoted to the 65% promotional quota of district judges YD government notification dated 30/3/2015 with immediate effect. As stated above, there were 45 vacancies in the 65% promotional quota on 1/3/15, and all the 39 judges were substantively appointed against clear vacancies in the 65% quota. Copy of the government notifications R1. My Lord, in the records which we had flagged and placed, my Lord, I'll again do that, my Lord, if your Lordships would like to peruse it. I have indicated how this quota is worked out, which are the notifications on the basis of which the cadre strength is worked out. All that is flagged, my Lord, in the record and kept also. And they are available, my Lord, for your Lordships, kind perusal. Then, Lord, please go to the next page. Para 5, that is page 739. It is submitted that the cadre strength of district judges was increased from 259 to 307 by the Government of Karnataka notification dated 26/3/15 due to the creation of 48 new courts. On 1/8/2015, the sanctioned cadre strength of district judges was 307. 65% quota of the sanctioned strength for promotion of cadre of civil judges senior division with seniority come merit would amount to 199. Working strength and vacancy position in the 65% quota of district judges on 1/8/2015 is as below. Total 307. 65% would come to 199. Those who are holding posts were 154. 45 were still unfilled in that 65% stream. Then para 7. It is submitted that 41 judges, including respondents 48 to 82, they are the contesting respondents, were promoted to the 65% promotional quota of district judges by the government notification dated 13/8/15. As stated above, there were 45 vacancies in the 65% promotional quota on 1/8/15. All these 41 judges were substantively appointed against clear vacancies in the 65% quota. A copy of the government notifications R2. It submitted that the cadre strength of district judges was increased from 307 to 315 in September 2005, that's just 1 month later, due to the creation of 8 posts of additional registrar inquiries, Karnataka Lokayukta, Bengaluru. In October 15, the cadre strength of district judges reduced to 314 as 1 post of additional secretary to government ceased to exist. On 21/1/16,
this increase in cadre strength,
yes,
which is referred to in para 8,
yes, ma'am.
was by what procedure?
Cadre strength is determined by the number of posts that are sanctioned. So whenever, my lord, like for example in para 6, my lord, we pointed out that certain extra posts were created for in para 8, my lord. Originally it was 307. When 8 new posts were created and notified, those notifications are also placed on record, my lord.
So this is as per procedure.
Yes, whenever, my lord, a new post is created and there is a government notification to that effect. So instead of 307, it became 315. So 8 new posts were
Now
created.
this increase in cadre strength is traceable to power under which rule? Our High Court.
Cadre strength, my lord, is only on the basis of the notification.
Okay, but the
By executive my lord, order, in consult with Chief Justice, my lord,
Yeah.
the DPR passes the order. That is the cadre strength. Here, there is no such notification. Only creation is there, temporary and permanent. There is no such notification.
The contention, my lord, is that there is no formal procedure by which the cadre strength is determined and a notification is issued. How the High Court administration has proceeded is that there was certain number of posts that were created. They were holding office. Whenever the government permitted the increase of that, the cadre strength increased because there's no specific rule which says you must do it in particular manner. But as a matter of fact also, these additional 8 posts were created and 1 post was reduced because they didn't want one more honorable judge sitting as additional secretary there. Then, Lord, if I may continue para 9 at page 740. On 21/1/16, the date of government notification appointing petitioners, the sanctioned cadre strength of district judges was 314. The 65% quota of the sanctioned strength for promotion in the cadre of civil judge seniority come merit would be 204. Working strength and vacancy position 65% quota was below given. 314, 204 could have been done, 193 were holding. So there were 11 posts. In view of the foregoing paragraphs, it submitted that clear vacancies in the 65% promotion quota existed at the time of promotion of respondents 13 to 82. All of them were substantively appointed in vacancies in the prescribed 65% quota.
Just
Go to the-
yes. Yes.
Then, my lord, I was reading, my lord, at the bottom of 740, I'm sorry, 741, paragraph 10. In view of the foregoing paragraphs, it is submitted that clear vacancies in the 65% promotion quota existed at the time of promotion of respondents 13 to 82. All of them were substantively appointed in vacancies in the prescribed 65% quota. Even at the time of petitioner's appointment, 11 vacancies existed in the 65% promotional quota, and the contention that there were promotions in excess of the 65% quota is wholly misplaced, ought to be rejected. Then I have said, my lord, that they have not challenged the appointment of 13 to 82. I would only invite your lordship's kind attention, my lord, to a memo that we have filed on 8/9/25, which gives, my lord, the tabulation of the cadre strength. There's a statement. It is dated 8/9/25. Honorable Court wanted this, my lord, so we compiled it and filed it, my lord. The memo reads like this, my lord. Sikta. Stated 8 September 25. It's a memo which is a tabulation statement along with all the notifications of government regarding increase of strength.
So separately filed.
Pardon? Yeah. Separately filed. It's not part of the 3 volumes. Because in the course of hearing, my lord, the Honorable Court expressed that they would like to see how you have arrived at. Because one of the arguments addressed with the other side, as my learned friend just now tried to interject, my lord, was that yes, government notification may be there, but there's no formal notification to say the cadre strength is from X to Y it has come up. No such formal notification is there. So they're saying you cannot take note of these notifications. You have to go by whatever historically was fixed. And at no point of time, that's what we have pointed out. There was no system of any issuance of cadre strength notification like that.
No, but now under what are the governing rules?
There are no rules which says that cadre strength must be notified in this manner, my lord. Cadre strength simply means, my lord, that the government is approving so many posts to be held as district judges. That's all it means. That's cadre means people who are on that category in that status. That's all it means. And how not now, my lord, for more than 30 to 40 years, that's how it has been done. Till now, nobody has questioned it. If your lordship could find the memo, my lord, or I can come back to it later, my lord, just to save time.
It's there. It's 8 months.
8/9/25 ನೋಡಿ ಈ ತರ ಇದೆ
Anjana,
ಈ ತರ.
ಆ ಥರ.
It's 8 months.
It's quite a thick memo with 142 pages.
Only one is copy you have taken.
Vijay.
ಒಂದೇ ಇದೆ.
2 ಇದೆ ಸರ್.
One extra.
ಒಂದು ಬೇಕು. Yes, sir.
I will not read it, my lord, but just show your lordship, my lord, how this computation is arrived at. In the memo, my lord, we say a statement showing the cadre strength and subsequent increases. along with notifications. Your lordships may take the first. It starts with 155, which was the position on 1st February or January 2003.
Page?
It's page 1 of the memo. Not first page is the memo. The second page is the tabular statement. So we start with 1/1/2003. What was the strength? Then every time notification government order is issued, we have kept on adding. In 2002, one post was created. It became 156. Progressively, my lord, as and when increases took place. And when come to serial number 10, they abolished charity commissioner. So one post came down. And every notification that caused a change, the cadre strength kept going up and down. And the type of notifications and total your lordships will get at page 4314. Now the kind of government orders, my lord, are your lordships will find I'll just show one or two of them, my lord. The first one is government order of 15th February 2002. It should be, my lord, after page 4, first notification. After careful consideration of the relevant facts, explained preamble, sanctions hereby accorded for the establishment of special court at Bangalore to conduct trial of heinous crimes committed by so and so, so and so. Sanction is accorded for creation of the following posts to the aforesaid special court. District Judge 1 post, etc.
Yes.
My lord, this is the main contention, my lord. So my submission is that cadre strength means number of posts that could be filled as approved by the government. That has been progressively maintained like this. So we have gone by that. Now, my lord, if we accept their argument, it would, my lord, lead to very startling consequences. Supposing, my lord, 10 posts are created and there is no notification issued. They are also judges to be appointed to those positions. Because notification is not issued, cadre strength will remain at, say, 100 instead of 108.
There's another way of looking at it. Suppose there is a vacancy in the Lokayukta where you have a district judge who may be posted to a certain post. Then you post somebody there. No doubt you may get a government order to post. Now let's assume that he, after 3 years, he comes back. Then you post him at some judicial function. The other way of looking at it is he only goes there by deputation and the lien continues in the parent cadre. So in that sense, one way of looking at it is there may not be an increase in the cadre strength as such, though there may be some posting here, there, etc.
That's why, my lord, these notifications say they are created. The notifications say post is created.
Let us read this page number 1 of
Yes.
these proceedings.
Preamble, my lord.
Yes.
Government letter dated 7/6/2001 and 25/8/2001 had requested the Honorable High Court for establishing a special court at Bangalore to conduct trial of heinous crimes committed by notorious so-and-so gang. The High Court by its letter has given concurrence for the establishment of special court at Bangalore to conduct trial of heinous crimes committed by so-and-so. The letter of the High Court has been examined in detail. Following orders are issued. After careful consideration of all relevant facts as explained in preamble, sanction is hereby accorded for establishment of special court at Bangalore to conduct the trial of so-and-so, so-and-so. Sanction is accorded for the creation of the following post to the above said special court. So when they set up a special court, later, my lord,
Yes.
Yes.
later for whatever reason, my lord, if that case is over and that court is no longer required, then that post will be abolished. Because here it is a case of creation of a post. Similarly, my lord, if your lordships could please turn to handwritten page 6, my lord. It is another government order of 15th February 2002.
So can these created posts can be part of the cadre strength is the question.
Yes. Yes.
Because they are only for a limited purpose. Once
Not
that-
necessarily, my lord. In some case, it could be limited. In some cases, it is not limited. For example, my lord, in many cases, they increased the cadre strength because in Lokayukta, they needed 8 judicial officers. So they increased the cadre strength. And they said 8 more people can be appointed there. And those posts continue. Otherwise, my lord, they'll become dichotomy between some posts which are originally there. Some judicial officers are discharging those functions, but they are in Trisanku. They're neither in cadre nor outside cadre. It can't be so. Wherever a post is created and a sanction is given, after all, my lord, cadre strength means what, my lord? If I ask myself that question, it means how many judges are functioning. That's all it means. It doesn't mean anything else. So if you look at it from that point, that's how the High Court administration has looked at it. In fact, this has gone before the committee, special committee, full court, everywhere. And it was nobody's case that cadre was not changed. Otherwise, my lord, it would be difficult to, then if they're sanctioned, if they are treated as not part of cadre, then what salary will be paid to them? From where will the salary be paid? Will they be fixed at some different rate? Are they district judges officiating in that capacity, or are they some ad hoc somebody? Like fast track courts, that's what happened, my lord. This is a special funding that came from central government. Therefore, the states.
No, if you look at next to second page, it says they have been created, these posts are only for a period of 1 year.
True. Now, my lord, if it is created for 1 month, and at the end of that period, my lord, if the work is over or for whatever administrative reason, government decides that this court need not function like this, and of course that can be done only on recommendation of the High Court. And once that is done, and if that post is created, that court is no longer there. In fact, that's what happened in fast track courts. Whoever was posted in fast track courts, their eligibility to be promoted as district judges was not an issue. Because they needed, they said you are taking the post, and they were posted and they've given all the benefits. But there was a rider, and that is because of the judicial determination, where the Honorable Supreme Court said that if he is placed in that position, he or she will get all the benefits of the promoted post only when original eligibility comes. So all of this will be impossible to work if we interpret it in the manner that they're saying.
It's no deputation.
Yes.
Just one more, sorry.
calculation that is being done in your tables, say sanctioned strength. When you're referring to sanctioned strength, you're also referring to these posts that.
Yes, my lord. Our case is that if it was 155 initially, as we pointed out in this. Yes. Yes, my lord. Yes. 314 your lordships will get in my table, my lord. So, yes, my lord. That is why I filed this compilation. That's yes, my lord. No, no, no. It includes. That's why, my lord, if your lordship sees the table, I give an individual notification for every post that is created. So it started with 155. Your lordships may just see one of them, my lord. Just now, page 1, your lordship saw one order, my lord, government order. That is 15/2/2002. On 15/2/2002, one post was established as special court. So that one, I have added it in the table. So it became, instead of 155, it became 156. Yes. Yes.
The increase in strength, then increase vis-a-vis creation of force, etc. So that let's see how it goes.
It's here, my lord. This chart is there. If you want, if your lordship wants something.
If you want a consolidated chart, then it shows at year X, this was what it is. Then how it increased.
It's here, my lord. If your lordship doesn't mind seeing page 1 of the table, my lord, in this memo, page 1 only, exactly that is there, my lord. In fact, this is the court expected it, and I have furnished this. If your lordship will start with the first figure, 155 is there. Then, my lord, 15/2/2002, one post. With every government order.
But then we have to see the rule under which is cadre. There must be some rule.
There's no rule for cadre declaration.
Under 309, whatever it is, how you are going to say, I'm saying there must be, this must be traceable to something.
It is traceable to government order, my lord. Post, creation of a post is done by the government. That's how it has been done all along. There is no notification.
Yes, let us.
Not just to suit their convenience, my lord. Now their argument is a very stretched argument. Their argument is, though there are 314 honorable judges sitting as district judges, as per all these orders, don't consider 314. Consider something less. Why? Don't take note of this, because there is no cadre increase. Meaning of cadre increase is that number of posts are created and they are occupying the position, they are paid salary, they'll get pension, all the other benefits, everything. What else is there is a question I would ask myself. So their argument is rather stretched.
No, so you are saying that let's assume that they've been holding that special post. Even after that period, in effect, they continue as district judges, may be deployed elsewhere.
Yes, what may happen, my lord, is if there's some post is abolished. Now, my lord, honorable district judge was seconded as secretary, law secretary. Now there is some rethinking whether it should be there. So you withdraw that post, you withdraw the position, the person who's posted there. But unless there is a notification which says, for example, fast track courts, there was a notification which created it, there's notification which abolished it, which means there is no court, fast track court. So whoever the honorable judges sitting there, they go back to their respective positions, wherever they were, or they would be. So to argue now that though there are these notifications, which increases the, after all, this stream quota, let me ask myself this question. If 100 people are there in the cadre, 65 should come from this cadre, from district judges being promoted. What they're saying is, no, it's not 100. You treat it only as 50. And from 50, instead of 65, it should be 37 or 38. Since you have promoted 65, the difference between the two is illegal. No, but there are actually posts are there and judges are holding those positions. Now, a senior civil judge, my lord, who is eligible for promotion in that category, in that quota stream, they will also say that there are 314 posts are there. So you please reckon 65% of 314. Why should you reckon 65% of 250 or so? The whole object of the stream is that that respective category will get this chance to go to the higher level. We can't extend it in such a artificial manner to say there is no notification and therefore there is no cadre at all. That, my lord, would not be correct is my submission.
Court is created. For that, we will recruit someone. We will not do it. We will only send somebody from here. What is amount to?
Yes.
I have one submission. For example, 8 posts addition register.
We'll come back. Let them finish.
Yes, sir. To clarify here itself, not I'm making the submission. Post of addition register in Lokayukta will be filled up by not by the cadre of district judge or by IAS. Whether, my lord, it can be treated as a part of the cadre strength. And there are 2 methods of recruitment.
Let us. Yes.
My lord, the contention, now I come to the order of the learned single judge, my lord. Kindly, my lord, take the first volume. I'll only read, my lord, the contention and how the learned judge has dealt with it. Serial page 66. The second line from top. This is part of para 3, which is a lengthy para, my lord, but second line at page 66. Thereafter, the government by notification dated 26/3/15 passed the final seniority list promoting respondents 13 to 47 as district judges from the cadre of senior civil justice effect from 1/4/15. It is the grievance of the petitioner that there was no vacancy available to promote the contesting private respondents under the promotional quota, and the said promotion granted to them is in excess of 65% quota meant for promotees as per the judgment of the Supreme Court and All India Judges Association. Then they were appointed, etc. I'll then, my lord, go to one more place where they raise the same contention at page 86. Middle of that page. The sentence begins like this one. It is at this stage. The grievance of the petitioners is that the private respondents have been promoted as district judges, wherein absence of vacancy available to promote these private respondents under promotional quota, which is in excess of 65%. Then, my lord, number of decisions are all referred to. Your Lordships may go to the consideration of the merits of the case. At page number 117, para 28. It is well established principle in law that to enable the seniority to be counted, the incumbent of the post has to be appointed, promoted in terms of relevant rules. It is to be noted that whether the initial appointment has been made for officiating or some purpose, such officiation in such post cannot be taken into account for consideration of the seniority. And for the reasons stated above, this next portion, my lord, is incorrect is my submission. As there was no vacancy available for the promotion to in excess of 65% of the respective quota, therefore the promotion made by respondent 3 is contrary to law, and as such petitioners have made out a case for interference. But there seems to be some little variance with what the learned judge has said earlier. Where we have pointed out the various figures, my lord, which were given. But this seems to be, my lord, the conclusion without specifically pronouncing on the question as to what is the effect of government notification and whether that can be taken as increase of cadre strength or no.
No, where is the discussion pertaining to this by the learned single guy?
Yeah, your lordships may please go, my lord, to. In fact, that part of the discussion is not there. Then the judge doesn't record a finding.
I think we should read para 27.
I will. Page 112, para 27. Having taken note of the declaration of law made by the division bench of this court and the Honorable Supreme Court referred to above, I am of the view that seniority between promotees and direct recruitees shall be fixed according to the quota rules as ordered by the Supreme Court in all India judges. That is to say, any promotion of the promotees or private respondents in the present case exceeds 65% rota quota rule. Such promotion is contrary to judgment of the Honorable Supreme Court. Accordingly, such excess promotion made to private respondents is required to be reverted to original post. Therefore, seniority of the petitioners will be fixed from the date of their appointment in their quota. So this also doesn't actually address that issue. The rest of the discussion your lordships will get at page 138. Last two lines, in para 33, initial portion is regarding fast track court judges, the submission which I just now made. On careful examination of the impugned final seniority list, nothing is stated by respondent 3 regarding their ranking as against the substantive post, vacant post. Therefore, I am of the view that the impugned final seniority list required to be set aside in terms of observations made above. And the operative directions are at page 140. Final seniority list, annexure so and so and N are set aside. Direction issued to third respondent to publish seniority list accordance with law in the light of observations made above. The observations made above, my lord, at page 112 is to revert them. He is contesting respondents. Page 112. The sentence begins like this. Accordingly, such excess promotion made to private respondents is required to be reverted to original post.
But it has not been quantified.
Therefore, my lord, my submission is that after all, my lord, something which has happened for a long period of time, it's not that suddenly some rule was changed and some procedure was changed. This, I gather, my lord, is the practice that has been followed right from, at least the record now shows from 2002 onwards. Even prior to that, that's what they were doing. There was no formal notification. They took note of number of posts that could be filled. That is the meaning of Kaida. That's one way of looking at it, my lord. And it's not, there's not their case that it was done to hurt somebody or help somebody or anything. It was the